Welcome to the Boston Barrister, Kevin Patrick Sieber, bringing you insights about your family and the world.
Welcome to the Boston Barrister. My name is Kevin Patrick Sieber. I am located in Boston, Massachusetts. Today's going to be a podcast about Massachusetts Department of Children and Families fair hearings. And one of the nice things I like about the Massachusetts Department of Children and Families is that they make out these titles like fair hearings. Let's be clear about this. Right out of the box, let's come after DCF. These fair hearings are only fair if you make the hearing fair. And how do you do that? You got to level the playing field and know what you're doing and understand how to do it. Because if not, you will not be successful. So there's pitfalls and things that you need to watch out for. I begin with telling you that most fair hearings are done now by what's called a team meeting. It's the same thing as a fancy schmancy word for Zoom. It's over the computer. You get a link, you go on the link on the appropriate time, date, and that's what happens. Now, years ago, they used to do fair hearings in person. But I think due to technology, which I welcome and we all should, we've made life a lot easier. And we do them by Zoom. Because people then don't have to travel out to the western part of the state, or Cape Cod, or down to the islands, up north all the way up to the New Hampshire border. And it just appears to make life a lot easier for all concerned. I want to back up a little bit. When and how do you appeal to a DCF fair hearing? Well, first of all, if you have a matter in which a decision was supported against you, because it starts off with a 51A, it's either screened in or screened out. If it's screened out, it doesn't go any further. If it's screened in, it goes further. And you assign a 51B investigator, or what DCF likes to call a response worker. Now, that response worker either has 5 days in an emergency situation or 15 days in a non-emergency. But often I see these go beyond their time standards, or the 5-day turns into a 15, and then they continue it from there also sometimes. Now, at the end of the rainbow, when the 51B investigation by the response worker is completed, they can come up with various decisions. The first, which we all hope for, is that the decision was not supported. Everybody goes home happy. Can you hear me, DCF? Everybody goes home happy. That's worth repeating a third time. Everybody goes home happy. The second is where the decision is boo, supported. Give me another boo, and a third boo, supported. And that can happen. Now here's the tricky part. That can be supported for a decision of child abuse or neglect, or it can be a substantiated concern. Regardless of whether it's a substantiated concern or just an outright child abuse and neglect allegation supported, you have 30 days to appeal this to the DCF fair hearing unit. Now during this period of time, you should receive a letter from DCF, but don't hold your breath because sometimes they don't. Sometimes, in fairness to DCF, mail gets lost. According to the United States Postal Service, 4.9% of the mail is lost, destroyed, or misdelivered every day. Now, I don't know about you, but if I put something in the mail, I expect it to be delivered. But 4.9% of the mail not delivered? There are numerous ways to get in touch with the Department of Children and Families, and I urge you to try all of them to make sure they do not time bar you from having your right, your important right, to appeal a decision to the Department of Children and Families Fair Hearing Unit. First and foremost, if you're going to send it by mail, send it by regular mail as well as certified. It's a few extra shekels, but it's money well spent. You're going to send that to the Department of Children and Families Fair Hearing Unit, located at 1 Ashburton Place, 3rd floor, Boston, Massachusetts, 02108. The second way you can send it is by fax. Fax number, you're going to send it to the Department of Children and Families Fair Hearing Unit, and the phone number is area code 617-748-2062. Third way to send your request for a fair hearing to the DCF Fair Hearing Unit is by email, dcffairhearingunit@mass.gov. The fourth way is to hand deliver it in person to 1 Ashburton Place, 3rd floor, DCF Fair Hearing Unit. Make sure if you hand deliver it, you get the name of the person that you give the document to with their title and have them sign off on it. I also suggest you do is if you get a document from the Department of Children and Families, there'll be a formal letter saying an allegation has been supported against you. You include that with your documentation, whether you do it in person, by hand, by snail mail, by email, or by fax. Include the letter, because that'll have your name, your address, the allegation against you, the name of the child or children that have been abused or neglected. And you want to give DCF notice. Due process requires fair notice for opportunities to be heard. So you want to be fair with DCF. Even though you feel as though this decision is unfair, this is your opportunity to appeal it. How do I file for my fair hearing with the Department of Children and Families? Always, always, always remember you have 30 days from the receipt of the letter from DCF indicating that you have a right to a fair hearing. If you do not file this within the 30 days, you can be time barred from getting your constitutional right to appeal this decision supported against you for child abuse and neglect by the Fair Hearing Unit. That's a no-no. So make sure you protect your time standards. Now, once you get back a piece of paper, and you will, DCF has 20 days to send it to you regarding your fair hearing. It should have the time, the date, and whether or not it's by team meetings or whatever it's going to be. It should also have the name of the docket. Usually, for example, it'll start off with the year, whatever the year is, and then it'll have a bunch of numbers after that. And that's your docket number. You also will have the fair hearing officer. The fair hearing officer is the one that'll be doing the fair hearing. When you correspond with DCF, you're going to want to speak to the fair hearing officer's paralegal. They should also be on the piece of paper. If they're not, call DCF at their main number, 617-748-2020, and ask for the paralegal for the fair hearing officer and state that person's name. Get their phone number, get their email address, and correspond with them. Now, common questions I get all the time about fair hearings is, Attorney Seaver, I recently got a phone call from a woman saying, I cannot make the fair hearing. How do I continue it? And this is commonplace and happens often because DCF just randomly sends out dates. They may or may not be convenient for your schedule or for your witnesses' schedule or your expert witnesses, or you may have had a doctor's appointment or a vacation or a death in the family. So all types of reasons why you continue a DCF fair hearing, but make sure it's with good cause and make sure you do it sooner than later. Why do I say that? Because it costs you time and money to redo this all the time. You don't want to do that. You don't want to expend your energy, but you also want to make sure you hit the mark. So if you've got a legitimate reason, write to the fair hearing office and ask them to continue your matter and tell them your good cause and good faith reason why. The DCF fair hearing officers usually are very fair. So you want to make sure you do it sooner though. You don't want to wait a week or 2 weeks before the fair hearing. You want to do it as fast, as quick as physically possible to give DCF an open honesty to be able to continue this. Remember, DCF has social workers and supervisors that have to show up for the fair hearing too. So you're not the only one that's been inconvenienced. At times, DCF will ask for continuance for very valid reasons. Don't ever argue about something that is procedural in nature, like the date or the time, location of a fair hearing. But you do fight like a banshee over things that are substantive, that have to do with the case being decided in your favor or against you. So once you get the DCF date, time, name of the fair hearing officer, what happens next? The next step is to prepare. There's 3 stages to a fair hearing. The first is the pre-preparation for the fair hearing. What do I mean by that? Well, you got to find out and get all the records from DCF of why they supported this decision. So the first thing you want to do is send for the 51A report and the 51B investigation. You're going to send that to the DCF area office where it was supported against you, where the response worker came from. You also want to send your notice, obviously, to the fair hearing office to let them know that you've appealed for this, that you've asked for the records, so that when and if you don't get them, and oftentimes you don't, you can appeal that. You can ask to have a continuance or some other reason they should have produced but didn't produce documents that are important to your case. Now, when you get the 51A report and the 51B investigation, read through them. There are going to be times when there might be a video involved or photographs, but yet they're not included with the 51A or the 51B. You are entitled to that. So how do you go about getting that, Attorney Seaver, when I don't get all the documents and evidence and facts I'm supposed to from DCF? in my file. Simple stuff. You write a request for a subpoena to the paralegal and the fair hearing officer on your case and ask them to subpoena the documents or the photographs or the videos into evidence. That you asked for your entire file, include the letter you sent, and they didn't give you what you requested and are required to have. You should not be blindsided. You should be able to get this information and be able to read through it or watch the video or see the photographs and prepare for your hearing. What is the terminology that is used when I'm looking to get documents or videos or photographs from DCF? The simple answer is it's a fancy smancy word called due process. And all due process means is that you get fair notice regarding opportunities to be heard. This is stated in the United States Constitution that you have due process rights. It's also stated in the Supreme Court of the United States, which is the highest court in America, as well as the SJC, Supreme Judicial Court of Massachusetts, as well as in the Massachusetts Constitution. Article 14, that you are entitled to due process. You're only entitled to due process if you implement and execute and go forward and get DCF to do what they should do, which is provide you with information about why this decision was supported against you, why it's bogus, baseless, and false. Simple stuff. But just because it's simple doesn't mean it's easy. You will get pushback from DCF. You can take that to the bank. But don't be going and calling the ombudsman or this one or that one. Go right to the source that didn't give you what you wanted. The area director doesn't give you what you want. Call them, email them, and write them a letter. Give them an opportunity to clean up what they should have sent you. If you don't get satisfactory, you can file what's called a grievance. And they have 21 days to answer that. You can also go and send a subpoena. You can also file, once the subpoena and the grievance is not honored, you can file a complaint in the Superior Court. Now, there's a lot of time and money and effort spent here, but if the information is of that importance, leave no stone unturned. Be like a dog with a bone. Be relentless. Now, the pre-preparation, what does that mean? Pre-preparation of the DCF fair hearing. The pre-preparation to the DCF fair hearing means the following, that you've got to get your witnesses lined up. You know DCF's going to testify. That's usually the response worker and the supervisor. You also have to get your 51A and 51B, all your ducks in a row, and make sure you have all the evidence. And also third parties. Maybe you need affidavits. Maybe you need to get evidence and facts from third parties. So you want to make sure you get that in affidavit form if they're not going to testify. If they're going to testify, then that's fantastic. You're also going to know something, and this is going to be a real secret that DCF doesn't want you to know about fair hearings. So what is the biggest secret that DCF does not tell you and you will not know when it comes to a fair hearing? The biggest secret DCF will not tell you regarding the fair hearing is that the response worker, the social worker who investigated the case, who supported this against you, is looked upon as an expert in the field of child welfare, as is DCF. Now, in some instances, some of these social workers are outstanding. They are experts. And in other cases, not so much. But you got to fight fire with fire. You've got to not only get your own expert, but your own experts, plural. Your experts that you have testify at your fair hearing have to be material and relevant as to what they're speaking about, and be able to illuminate the fair hearing officer on things that perhaps lay people don't know. And I think that there is many things that we all don't know. And what you don't know is what's going to get you into trouble. That's why you hire experts. Prior to the fair hearing, what you do is you get all your questions and answers based upon the 51A report and 51B investigation. And you have the fair hearing be staged like a play, so that everything is known before you do the fair hearing. No questions are asked that you don't know the answer to. And when you have the DCF response worker under oath, then you ask them questions, not to beat up on them, not to bully them, not to be insulting, but rather to get information. Your job is to prove your case and disprove the department's. In the department, I know some of you are going to scoff at this next thing I'm going to say, but I truly believe that most of the people at DCF are decent people because they're people. And I believe most people in our world are decent, whether they work for DCF or some other agency or on some other job. Most people are pretty damn decent. That includes DCF. Now, there I said it, okay? With that said, too, I have many people that have been friends of mine for years that work for DCF. I have the utmost respect for many of them. That includes the social worker, supervisor, area program manager, your clinical manager, area director, counsel of all types, regional, whoever, whatever. And they have a very tough job. They got to go into homes with complete strangers, ask questions that they feel very uncomfortable asking, they're as uncomfortable as you are. And when they make the decisions to support it against you, sometimes they really wrestle with those decisions and they don't want to do it. So let's give them the red meat before the fair hearing to unsupport it. That's what I say. But during the fair hearing, all bets are off. They supported the decision against you. You must prove your case with evidence, facts, as well as witnesses that take the oath, testify under oath to tell the truth, the whole truth, nothing but the truth, to help them God, and prove your case. So you need to gather the evidence, you need to gather the facts, you got to gather the affidavits, you got to gather the experts, and you've got to make it happen. You got to level the playing field so that you're treated fairly during this hearing that's supposed to be fair. During the fair hearing, there's going to be various objections you can raise, and you should object and raise. And anybody worth their salt who's a fair hearing officer doesn't take it personally. Some do, though. So don't let them throw you off your game. The fair hearing officers can't ask you questions and often do. So you need to be prepared for those questions and answers. Also, you can have the response worker or anybody from DCF ask you questions. So you got to be careful and you got to be prepared. That's the watchword when it comes to fair hearings. You must be prepared. So what's the most important thing you can do at a fair hearing? Be prepared. I don't want to sound like a Boy Scout or a Girl Scout, but it's so true. 9/10 of life is preparation. I don't care what you do in life. Trial lawyer, I don't care if you're a domestic engineer, I don't care what you are. 9/10 of life is preparation. The other 10th, delivering what you prepared. So everything at a fair hearing should be written out, questions as well as answers. And then you present that, and you get your story, and you get your best shot, so you get the best result at your fair hearing. Remember now, I'm going to be repetitive. Get your story out. Tell your story. Many people don't. They bumble, mumble, and stumble to the fair hearing. They're not organized, they're not coherent, and they don't tell their story. You must tell your story. There's a way to do it, and you want to make it interesting. There's nothing worse than being boring and bumbling, mumbling, stumbling in front of a fair hearing officer. After the fair hearing, there's major things you can and you should do. That fair hearing officer may not read or listen to the tapes of this fair hearing till months later. You want to give them a roadmap, a GPS, called the Findings of Facts, Rulings of Law. That's where you write the issue. Did Mrs. Jones neglect her 6-year-old son? And then you have the rule of law. What is neglect? And it's boilerplate. You can find it 110 CMR 2.0. And you put that down. Then you have the analysis section, where you analyze the 51A report, the 51B. In every case, the issue of whether or not the individual who's appealing this is a caretaker must be and should be discussed, because in some cases they're not. With that said, there's also other things, depending on whether it's sexual abuse, physical abuse, or neglect. Different ways to go about working with these elements. And you need to write about this and the analysis of why or why not this did not happen. In other words, you corroborate your story with the various witnesses, the facts, the exhibits, the evidence, everything you have, affidavits, and you write about it and why this should not be upheld, should be reversed and overturned. At the end of the analysis, you're going to have a conclusion section. You take the 3 to 5 most salient, important, critical terms of why Mr. or Mrs. Fair Hearing Officer, this case should be reversed and overturned. And you want to submit that. You ask at the end of the fair hearing for a couple of weeks usually. Sometimes we've asked for 3 weeks when there might be an impending trial coming up or vacation or something where we're not able to get it out in a timely fashion. And you want to make time always your friend, not your enemy. And with that said, as soon as you get done the fair hearing, you want to send for the transcript of the recording of the fair hearing, so you can layer that into your findings of facts, rulings of law. In other words, all the testimony. So nobody's guessing. It's there, it's here, it's what it is, and it is what it will be. You also want to do some case law. Look into what is the current case law status at this time. And there's going to be some cases that are in every brief, such as physical abuse. It's Cobble versus the Department of Children and Families. It's called the Reverend Spank-A-Lot case by my colleagues and I. But it's a seminal case. It came out, I believe, in 1999. But with that said, there's other cases that are very, very, very important, on point, and should be in your brief, should be in your findings of fact when you submit it to the fair hearing officer. Now, with that said, when you've done your findings of facts, rulings of law, you're going to want to send it to the fair hearing officer or at 1 Ashburton Place. Get the fair hearing officer's email and email it to them, hand deliver it, send it by certified mail as well as regular mail. You also need to send it to the DCF supervisor, depending on who shows up at the fair hearing, because that's only, again, due process, fair notice. If you're submitting something to the fair hearing officer, you need to send it to the DCF, which is the adversary or the other side, the other party. Now, with that said, there's many other things, tricks and tips that can be given about the fair hearing. But to put that into a podcast, this thing would go on for weeks. With that said, important, let's recap. Always file for your fair hearing. Even if you don't think you can win, make sure you protect your rights. Then look at it later by getting a 51A report and a 51B investigation. Have somebody that's competent to read the 51A and the 51B to tell you whether or not you've got a chance to overcome this, reverse and overturn it. Do not spend money, energy on something that's not a winner. There are some cases where you can't win, that the parent unfortunately has abused or neglected the child, and it's abundantly clear, such as in certain circumstances it might be bruises and marks all over the child. That's physical abuse. And it may be a situation where the child, there's some type of sexual transmitted disease left behind. Okay? That's sexual abuse. And there might be neglect, where the child doesn't have certain things, but should. And unfortunately, as a defense attorney, I'm loath to say this, but there is child abuse and neglect in our society. And anybody says differently, they're just not telling the truth. So with all that said, you need to work within the confines of the DCF process, procedures, protocols, time standards, statutes, regulations. Oh yes, the law. And remember, the United States Constitution says we, the people. Don't ever forget that. Good luck.